Welcome to Leia's Cotidianas, or Everyday Law, where we discuss the laws that affect you every day. Today, we will be discussing abusive litigation and frivolous lawsuits. How can these lawsuits be filed? Why are they not stopped? And how can they be curbed? We have with us today two guests who will discuss these issues and many more. Our first guest is Frank Beltran of the Beltran Law Firm. Frank's an attorney who's been practicing law for 30 years and is very knowledgeable in the laws that deal with abusive litigation tactics. Thank you for joining us, Frank.
Thank you, Charlotte.
We also have with us John Krieger of the Georgia Chamber of Commerce. John Krieger is the Senior Vice President of Public Policy, and he's here today to provide us the business perspective with regard to frivolous litigation and abusive litigation. Thank you for joining us.
Thank you.
Okay. Before we get started, let's actually talk about what we mean by frivolous lawsuits. A lot of times we hear about the famous lawsuits, or what I will call the sort of notorious litigation matters, such as the McDonald's coffee case, where the woman was burned after spilling coffee. There's another recent one with regard to cleaners and someone suing a cleaners for pants that were ruined. But Frank, from the legal perspective, how do the courts view claims, and how does the courts determine whether a claim is considered frivolous or whether parties have engaged in abusive litigation?
Okay. If I could, by way of introduction, in the United States we follow what we call the American rule. When the founding fathers were deciding what we should have in our Constitution and Bill of Rights, they looked at the English rule, and the English rule was that the loser pays. And what the founding fathers wanted the citizens of the United States to have: equal justice, personal responsibility, liberty, and personal freedom. And so they decided with the American rule, which means each party pays their own. Now, there can be, as you said, frivolous lawsuits, and there are ways, and we can get into more detail later, in Georgia in particular, how they're dealt with. A frivolous lawsuit is a lawsuit that has absolutely no merit, one that is substantially not justified either in fact or in law.
Okay, all right. And John, from your perspective, with regard to businesses, what kinds of lawsuits, from a Georgia business perspective, are you hearing about that businesses often regularly face that they may believe are without merit and without substantial justification?
Well, Charlotte, I mean, that's a good question, and really businesses face a host of suits. I think recently we've seen an explosion in the costs of dealing with some of these cases related to discovery costs, particularly when it comes to electronic discovery. Okay. Just the volumes of information, the cost of trying to produce that information. It's become, we've heard specific cases where companies, although they felt 100% sure they'd win on the merits, were forced to settle these cases just to avoid the significant costs. And as a Chamber of Commerce and an entity, an organization that supports business and job growth, we see that as unfortunate, because those costs that are either forced to deal with cases that don't have, companies don't believe have merit, or settling these cases, all those costs are costs that won't be used to grow their business, hire more employees. So, you know, frivolous sometimes is, although there may be some legal definitions, fighting those cases have true economic costs on these businesses.
Now, when you say discovery, for folks who may not really understand what that term means, discovery is the process where, after a lawsuit gets filed, the various sides determine the various evidence that is out there to investigate a claim. Is that what you mean?
Correct.
By discovery? Okay, and you mentioned a particular term, e-discovery. Yeah. What do you mean by e-discovery? It's a relatively new term.
Sure, it really refers to electronic discovery. That's emails, that's company documents, that's instant messages even that are sent electronically, and all that information is subject to discovery and production.
Okay, and so someone at a business is going to be charged with the task of going through all of those various emails, and now with the proliferation of emails as the primary form of communication, that becomes a pretty daunting task.
Yeah, I mean, there's studies showing some of the costs to produce that run from the hundreds of thousands to the millions. Okay. And there's very punitive costs that the courts assess if you inadvertently fail to produce what turns out to be, after sifting through all that, you fail to produce, a document that is substantial. So it's really behooves the business to have to go through all of it and produce all of it. I've seen through a survey that businesses are producing on average 1,044 documents in discovery per one page that's produced as an exhibit in the court.
Okay.
So it's just voluminous and costly.
And it sounds like your other point is that oftentimes even if a lawsuit is filed and while the business may believe that they have defenses to that particular claim, that in weighing from a cost-benefit analysis the cost it's going to take for them to continue versus simply seeing if there's a amount of money that could be paid to the claimant to resolve it, that sometimes it's more cost-effective for them to do that?
Yeah, I mean,
Okay.
there was a survey done by the American College of Trial Lawyers that found this discovery process was being used to, was abusive, and that, that this process was being used and that, majority of cases were being forced to settle just because of that very reason, because it's been abused and the cost to try to fight those, whether they're merits or not, was just too large.
Frank, let me turn it back to you now. With regard to a claim, the court system has in place mechanisms by which they can view or judge whether a case has merit or not and whether it's allowed to continue. Can you explain a little bit about that process and how does a court look at a claim and what is the process that the court goes through in order to, in essence, test the mettle of a particular case and to see if it's going to be allowed to go forward?
Well, two things. First of all, when we talk about frivolous litigation, if the litigation really is frivolous, the defendant in that case, let's say the claim is frivolous, the defendant will wind up getting their attorney's fees and their expenses from the other side. Many times the case is not frivolous, but somebody either on the plaintiff side or the defense side is abusive. And in Georgia, we have a number of statutes that allows the party to present an argument in front of the judge, and if it is abusive, for the judge to order attorney's fees, not only against the lawyer, but against the party, or both of them together. Okay. So there are mechanisms in place. What the judge does, the judge is a neutral arbitrator. We've heard of blind justice. The judge sits there and looks at it and says, is there any merit? Just because you bring a lawsuit doesn't mean you're going to win or lose. It depends for the jury to decide after hearing all the facts. And so the judge will look at it and say, was this in bad faith? Or was this was somebody stubbornly litigious? Was somebody causing unnecessary time or trouble or expense to the other side?
Okay, so let me see if I can break that down a little bit. There's a process by which the court can look at a case at the outset to determine whether there's even a valid claim. Is that what you're describing?
The court can. Now let me tell you what the Georgia courts have done. If you're a licensed professional in Georgia, and they have listed them in the Georgia Code, but in order to bring a lawsuit, you must have an affidavit from a licensed professional in that profession. In other words, if you want to sue a lawyer, you must get an affidavit from another lawyer who's either practiced or taught in the past 3 years and is familiar at the time of the incident. And so it's kind of like a check. And without that affidavit, you can't bring the lawsuit.
Okay, so it's a little bit of a litmus test. If you
Yes.
can't get another lawyer to give a sworn statement that in fact this is an actual malpractice claim, then the case doesn't get filed to start with, or it can't be filed.
Well, if it's filed, it'll be dismissed within 30 days, and that applies to engineers, applies to doctors, accountants, anyone who is licensed, and they have itemized the licensed professionals that you must have the affidavit. And so it's really a nice way where if someone files a lawsuit without an affidavit, it's dismissed quickly.
Okay.
And there won't be any discovery, and the person who files that lawsuit is subject to sanctions or attorney's fees or expenses.
Okay, so when you say they're subject to sanctions, that may be that the actual claimant, the plaintiff, would have to pay the other side's attorney's fees in defending the case? Is that?
That could happen if the court determines that it was substantially unjustified in either law or in fact.
Okay.
Or again, it will cause an unreasonable delay or expense to the other side.
Okay. John, let me ask you. Frank mentioned the cases that involve professionals, doctors, accountants, various licensed professionals. other than those kinds of claim where there may be a bit of a litmus test to at least, overcome a preliminary procedural hurdle to get the case filed, what other kinds of claims are your members talking to you about that they are being faced with that ultimately, at least from their perspective, may not necessarily be meritorious?
Well, we have a broad, member base
Sure.
across all professions and types of businesses, so it runs a gamut, but certainly I know the medical community faces what often can be, what they feel are litigation for malpractice that that they would say would probably be without merit. I know business owners, property owners are faced with a lot of what they consider nuisance suits. Particularly, in Georgia, there's a case right now going through the courts where a victim of a crime took place on property, and the victim is suing the property owner, but not the criminal. And our businesses see that, Georgia is no different than many other states where there's, jackpot justice, where you're going after the deep pockets. Now, had that criminal been, the argument had that criminal been had been wealthy, they'd go after the criminal, but they're going after a property owner that, arguably had nothing to do with that crime, yet they're faced with fighting the original case, the appeals, and on down the line. You'd mentioned early on the dry cleaner case. People laugh because thought it was frivolous. Well, unfortunately, those dry cleaners, Korean immigrants, were forced to argue that court case, at the trial level, at the appellate level, to the tune of $83,000. And so much so the frustration was, maybe in the end they could have gotten their attorney's fees back, but it was so burdensome to them and caused them such pain that they were considering moving back to Korea. So it really is, there's frivolous, there's nuisance, there's abusive, and our members come to us all the time with just having to battle those, and it is difficult for them to make business decisions.
All right. We'll take a break now, and we'll be back in just a little bit. Please join us for Leyes Cotidianas.
Desde el momento en que ellos llegan a nuestras vidas, dan su primer paso, aprenden a andar en bicicleta. Hasta la preparación de su primer día del 5º grado es un reto para todos los padres criar un hijo saludable. Permítanos guiarle a través de un embarazo seguro y feliz. Aprenda sobre salud, nutrición e información educativa relacionada con el desarrollo de su hijo. Padres e Hijos Atlanta, una publicación del mundo hispánico. Recoja su copia gratis hoy. ¿Cuál es su tesoro más preciado?
Welcome back to Leyes Cotidianas, our everyday law, where we discuss the laws that affect you every day. Before the break, we were discussing frivolous lawsuits, and John, you had mentioned a couple of the famous ones that we had talked about earlier and that folks have heard about, which is the McDonald's coffee spill case, and then also the case with regard to the suit against the cleaners for a pair of pants that was ruined. But Frank, let me turn it to you now, and with regard to the coffee case, for example, everyone cites that one as the quintessential frivolous lawsuit and, crying over spilt coffee in essence. Do you know any of the facts surrounding that? Oftentimes we simply hear that a lady was hurt with spilt coffee and then McDonald's ended up having to pay a substantial sum. Do you have any more information with regard to the facts of that particular case and the background?
I do.
Okay.
If I can just say,
Yeah.
in relation to the premises liability suit, the landowner is liable only if he has a duty and that duty was breached. For example, if it was the first time there's been a criminal involved, the landlord may get out on a motion to dismiss. However, if the landlord had noticed that the lock didn't work, or the window was broken, or that someone had been in that apartment complex, that business, on a repeated basis, and they haven't done anything, there's an independent and separate duty. So I think you have to judge each case as to what was the duty of the landlord. Sometimes there may be no duty, sometimes there may be a duty that the landlord just ignored and breached, or the owner of the premises, and under the law they're liable.
And if you don't mind,
Yeah.
Sure,
adding,
please.
there's also the proportionate liability. And
Okay. What do you mean by proportionate liability?
Let's say a criminal committed the act, but it was on property that, let's say, the property owner was didn't fulfill their duties. What's happening is the criminal is not being named in the case. They're going 100% for their damages to the property owner, And so is that fair? You know, or should the property owner be held proportionately responsible? But ultimately, it's the criminal that was committed the act. So those are the types of issues that take time and cost and to resolve in the court.
Sure. And it seems like at the end of the day, that's you know, where from a jury's perspective, they would look at that balance and try to determine whether or not there are facts that would have put that property owner on notice, or whether this was just a random occurrence that happened and the property owner had no idea that this was going to happen and this criminal was going to commit this act. But I understand your point is if they had no idea and there was no basis there, all of a sudden now they're defending a lawsuit simply because they are the party that would have money or funds upon which to pay for some kind of a recovery, and the criminal who's responsible ends up being allowed to go. Well, Frank, let me go back to, again, I think sort of the point is that each case has got its own individual facts, and only hearing portions of a case obviously is a bit of an issue. But with regard to the McDonald's case, can you give us a little bit more information? All we know is that people think someone sued over spilled coffee.
I'll be happy to.
Yeah.
From about 1982 to 1992, McDonald's had 500 complaints that their coffee was too hot. And the coffee was at 180 to 190 degrees, which means if you spill it, it will burn your skin, third-degree burns, in less than 3 seconds. If you dropped it to 170, you'd have about 9 seconds. If you drop it to 160, you would have almost 20 seconds to protect yourself. McDonald's, during the trial, and I'll get back to some of the facts, testified that at the time the coffee is given to the customer, it is not fit for consumption because it's too hot. Now, here's what happened. We had Stella, was an 81-year-old woman, never filed a lawsuit before, a grandmother. She decided to get some coffee. She was not driving the car. She was a passenger in the car. She had her grandson. They got the coffee, and the car stopped. The coffee wasn't moving, and she opened it, and she spilled it, and in 3 seconds, she had third-degree burns. She went into the hospital for 8 days. She had grafts in her groin area and her genital area. She was there for 8 days. She had some debridement, that's where they have to cut the skin, and some grafts, and then for 2 years, she was really disabled as far as walking and normal activities. Now, what she did was, that cost $11,000. She wrote to McDonald's and said, will you please pay my medical expenses? $11,000. McDonald's refused. She then hired a lawyer. She had heard it had another case against McDonald's, and he made a demand for somewhere between $75,000 and $90,000, and McDonald's said, here's $800. So they went to trial. And the jury heard it. When the jury first heard it, they thought, why are we here? But after a week of trial and of the experts and hearing all the testimony, the jury decided to give her $200,000 in compensatory damages. And they found her 20% liable, so they reduced it to $160,000. At the same time, there are punitive damages, and those are to deter someone for this conduct. And when McDonald's experts testified, we knew it wasn't fit for consumption. We didn't advise people of the risks. You know, that's just the way we do it. The jury realized they didn't care. So they awarded a punitive damages of $2.3 million, which represented 2 days of the coffee profits of McDonald's. And then what the judge set some of it aside. He actually reduced the punitive damages of $2.3 million, and they don't tell you this, down to about $600,000. And he said, I'll give you 3 times your specials. So actually it was less than that. It was a total of $600,000. Then the judge ordered it to mediation, so the case actually settled for that. But the judge, in his order, said there was evidence here to show that McDonald's was willful, wanton, and malicious in the way they handled their customers. And so a judge, as an independent fine factor, said there's facts here. But all you hear is the $2.3 million to spill coffee. Those are the facts. We hear an 81-year-old lady who had never sued before in her life, who had serious, serious problems, and said, McDonald's, just please pay our expenses. All it is $11,000.
Right.
And they refused to do that.
Well, it sounds like from what you're saying is, and I think for what we talked about a little bit earlier is there's, at least from the judge's perspective, there's a balance there. And the judge looking at that perhaps a jury may have gotten inflamed, but yet at the same time went ahead and made a certain ruling, and the court recognizing the various facts in the case has then apportioned it down, and there was a 20% apportionment, which is what you had mentioned earlier, John, with regard to apportionment of who actually is ultimately at fault for, unfortunately, an unfortunate circumstance. Let's talk about now, maybe change the topic a little bit to arbitration. Folks may or may not be familiar with what arbitration is, and arbitration is in essence an alternative source of resolving disputes outside of the court system, and sometimes these attorney's fees fees and these costs can be allocated at the beginning. John, what are you hearing from the various folks that are members of the Chamber of Commerce as to whether they like the concept of an arbitration, whether they're seeing it's something that they're able to utilize on a regular basis, or whether this is just something that it is nice in theory, but it's not actually panning out?
Sure. Well, many of our members support arbitration because they see it as a way to dissolve or handle a dispute outside the normal court system, which is expensive and can be scary for a citizen trying to bring a case in court they may not know. So building these into their employment or just the consumer contracts as an alternative method to deal with a problem. The challenge we're seeing is some of our members are being sued over those arbitration clauses because lawyers are claiming that's denying access to the courts.
I see.
So it's kind of, you lose for winning in trying to give consumers an opportunity to have a less scary, less costly avenue of resolution, but then they're being tagged out and being sued for those clauses. So it's
Yeah. What about businesses to businesses? Are you seeing where businesses have engaged if one vendor, or as opposed to a consumer, but a vendor with a business is having some success with perhaps resolving any of their disputes with regard to arbitration? Are you seeing that, or?
To be frank, I haven't heard any specific examples, whether it's working, whether it's not.
Okay.
I'm sure it is. We just haven't been confronted with that.
All right. And Frank, did you have something to add with regard to arbitration?
Two things. One, our Constitution of the United States, the 7th Amendment, where a Bill of Rights says a person has a right to a jury trial. The Georgia Constitution, which is Article 11, says the right to jury trial is inviolate. We believe that you ought to promote alternative dispute resolution, whether it be mediation or arbitration or this sort of thing. The problem comes in where a layperson in Georgia is told that if they have a case against a particular company, they have to use a panel made of members of that business. Or, if it's a car manufacturer, they have to use auto manufacturers on the panel. That's not fair. They also are told that if you want to arbitrate, you have to go to New York to arbitrate it. Now, someone on a smaller claim can't do that. So that's unfair. I promote alternative dispute resolution as long as it's in good faith by the other side. But you do have those problems that you have.
Let me ask you this. When we talked about the various cases, and unfortunately from a business's perspective, oftentimes they are looking at increased costs where they, on a balance, decide that it's easier to go ahead and resolve the claim than it is to just continue the process. The process itself is an expensive proposition. What if a claim ultimately is determined to be a frivolous claim? What procedures can a business, let's say for example, take in order to attempt to recover some of these costs? Let's say they can't get it resolved. They try, but they can't get it resolved. What processes can they go through to try to recover their costs if they ultimately prevail in a case?
Well, in Georgia, we have a code section, it's 13611, that allows you to recover fees prior to the litigation itself. So if you have a banking case where somebody actually owes the money on the note and they deny liability, that will allow you to have your fees from the very beginning until the end of the case. Then let's say that you don't have bad faith, stubbornly litigious, or unnecessary delay during this part, but you're in the trial. The business can file a motion at any time during the litigation, a motion for abusive litigation, asking the court to say, we think this is abusive, we think this is frivolous.
Okay. And can they ultimately then potentially recover back all of their expenses and attorney's fees in having to defend the lawsuit?
They can. They ultimately, if sometimes there's just one issue, maybe discovery, they would recover the fees as to discovery. But they have that right, and as I said, it could be against the lawyer and the client or both.
Okay, so the lawyer is potentially responsible as well.
Two issues with
One last thing.
that we hear from our members is it's difficult to get that ruling. And also when it comes to recovery, if someone doesn't have the resources, there's no recovery, and they've spent the time, money, and effort in battling this.
So you may have the right, but
Correct.
having the right and getting the ruling and then actually collecting on the
Correct.
ruling are separate things.
Correct.
All right. Well, I think we're about out of time, but I thank you both for being
Thanks.
with us, and join us on the next Leyes Cotidianas. Also, if you'd like more information, please join us on leyescotidianas.com, where you can find out more about this topic and many others. Thank you again.
Leyes Cotidianas, les llega a ustedes gracias al generoso apoyo financiero de la Fundación de Justicia Civil del Estado de Georgia. Mundo Hispánico, el vocero de la comunidad hispana desde 1979. La estación transmisora WPBA no tiene licencia para practicar leyes en el estado de Georgia. WPBA y los patrocinadores de este programa no son responsables por las opiniones expresadas ni la información proporcionada por los abogados en este programa. Este programa se ofrece como un servicio público. El objetivo de este programa es de informar y educar y no de proveer consejo legal. Si usted necesita consejo legal, favor de consultar a un abogado.